NACDL is the association of the nation's criminal defense bar.
Well, good morning, and I am at the ACLU in the Criminal Law Reform Project, and I want to talk a little bit about our work and sort of our broad goals when it comes to pretrial reform, and then turn it over to Colette to talk more about the practical implications for you all in courtrooms every day. And so, we're hoping that gives you a nice sort of broad to narrow view of how we can really attack this issue of mass incarceration in our pretrial system. And it is true, before I came to the ACLU, I was in Alabama doing death penalty work. And since coming to the ACLU, I found that there are actually some interesting parallels with the death penalty system that we were challenging in Alabama and our current pretrial justice system. To give you a sense of that, in 1972, the Supreme Court struck down the death penalty in this country. And there wasn't a single unifying opinion when the court issued this ruling, but the general consensus was that the death penalty was both arbitrary in terms of what types of crimes and what types of individuals are receiving it, but it was also racist, which, if you think about it, is pretty hard to pull off, to be both arbitrary and racist. And I think that very well captures the moment that we are currently in with respect to pretrial justice. So much so that I've come to the belief that when it comes to pretrial detention, we should not be willing to put anyone in a jail prior to their trial unless we are willing to kill them. And I mean that literally, as we know from the case of Sandra Bland, but I also mean that these individuals may die a civil death, which you've also heard about in terms of losing their family, housing, employment opportunities. So whatever the outcome is going to be devastating on that individual. And so we have to take it that seriously, in my opinion, if we are really going to bring any real change to the system. So using that framework, where do things stand? And Colette will get more into detail with this, and I think you've already heard, there are every day in our jails across the country about 630 people locked up. Fully 70% of those individuals are pretrial, and they have not been convicted of anything, and they are presumed innocent. And when you see the pie chart of our mass incarceration problem, which stands at about 2.2 million, 2.3 million people, that means that about 1 in 5 people who are locked in our jails and prisons are there without a conviction. That is a major travesty, and it's an emergency. So what are the consequences of that? Shouldn't be very surprising, right? Pretrial detention drives outcomes. As many of you probably know, a prosecutor's best bargaining tool in many cases is pretrial detention. So it's no surprise that those individuals who are locked up pretrial are more likely to be convicted, they're more likely to be sentenced to a jail term, and they are more likely to receive a longer jail or prison term. But more importantly, in some respects, just the experience of being in jail, controlling for all other factors, makes those individuals more likely to commit an offense once they are eventually released. Because we are devastating their lives, and what are they returning to? So the stakes are dire. So how did we get here? Well, like in the death penalty context, this is another story of race and poverty. Because currently in this system, we run what I would call a wealth-based pretrial detention system. Many of you are familiar with this system in your own backyards, but I'll just say briefly, we are in a system where whether or not you can afford a monetary bail, whether or not you can afford to pay for your liberty determines if you stay in jail for the entirety of your case or are released immediately. So the Robert Durst of this world can easily afford to buy their freedom, skip jurisdictions, whereas the bulk of people who can't afford bail as low as $500 have to sit for days, weeks, months, and even years in the Kalief Browder case before they can have their day in court. So it's not surprising also that in a wealth-based system, the consequences are felt disproportionately by people of color. All right? African American males are already 2.5 times more likely to be arrested by the police. And when they get into the pretrial justice system, their bails are on average 35% higher than white defendants. For Hispanic men, it's 19% higher. It all comes into play where the judge is looking at an individual defendant and trying to determine their quote-unquote risk. So before I turn to talking about the ACLU's litigation to try and break the back of this wealth-based pretrial system of mass incarceration, this death penalty of our pretrial system, I want to give you a sense of our broad goals here, right? Because I think one problem of many reform movements is that the momentum picks up and things begin to change, and we are in a moment of very, very rapid change, and there's not enough stopping and thinking and trying to make sure that we are cognizant of the long-term goals rather than reacting to the status quo and trying to improve things as much as we can in the moment. So I would lay out 3 specific goals of our work, and one is to end unnecessary detention. That's a loaded word, but it's my belief that once you decide to detain at all, you are going to over-detain. Once we have in our mind, as in capital punishment, once we have in our mind the idea of the defendant that deserves it, that idea can only proliferate and infect the entire system, and so we are going to put too many people in jail. So our goal has to be ending that instinct. And I separate this out slightly from wealth-based detention or even ending racial bias in detention, because obviously a great way to level a pretrial system is simply to detain more people, right? And so our goal has to be getting everyone out from under this system. But while we do that, we have to keep goal 2 in mind, which is to prevent what I like to refer to and many refer to as net widening, right? And net widening is this idea that, okay, we'll release you from pretrial detention, but you're going to have GPS monitoring, or you're going to be required to drug test, or you're going to be required to check in with the equivalent of a probation officer every week prior to their trial, right? So this idea that we can expand the net of people who are now under this system of supervision simply because we are not putting them in jail, and anything short of jail should be fine. I think we need to think very seriously about that and really enforce this idea of only imposing the least restrictive conditions necessary to ensure pretrial success. And lastly, and related to both those 2 goals, I think we also need to think about eliminating the profit motive from our pretrial system, right? We have a wealth-based system, and there's money to be made. So as I'm sure many of you know, when you have defendants who are forced to pay an amount of money to get out of jail, you introduce the opportunity for the bond industry to come in and profit massively off of those individuals who are so desperate to get out of jail. And increasingly what we're seeing in our practice, separate from the bond system, separate from the bail bond industry, is the emergence of privatized pretrial supervision companies. I'll talk about that a little bit later. But even as we eliminate the bond industry, which I think that we can and are hoping to do, we have to understand that there are still opportunities to profit off the backs of the people in our criminal justice system, people who are primarily poor and people of color. So those are the specific goals. But I think given the nature of this conference, we should also keep in mind what I would say is perhaps a broader goal, which is increasing racial justice in our pretrial system. And I say it that way because I want to get out of this mode of simply talking about racial disparities at every turn. I want to go to a point where we're actually thinking about how do we increase the humanity of our pretrial justice system? How can we use what's happening in our courtrooms to actually repair the damage that we have done to these communities through our practices in bail? And I think that should be the measure, right? To increase the level of justice, not simply reduce the amounts of disparity. So with that introduction, I'm hoping to leave some time for questions at the end, but I want to talk about 3 areas where the ACLU is actively litigating to try to achieve these goals. And the first deals with bail schedules and the immediate problem of wealth-based detention. And these materials are in should be with your packet. So I'm going to just cover them very briefly. If you want to go more in depth, you can look at the complaints that we've attached and the outline. But the basic idea is that no individual should be in jail pretrial simply because they cannot afford to purchase their liberty. And so far, the best litigation hook, if you follow the lawsuits by the Civil Rights Corps and Equal Justice Under Law, has been to attack bail schedules. And most of you are familiar, but I'll just say very quickly, a bail schedule is simply a system where the court applies a predetermined amount of bail to a crime. The idea is, I think, I'm trying to find a good way. I think the idea was a decent one, right? The idea is, if we can't get you into a court, say over a weekend, we can afford you speedy release by saying, okay, well, if you can afford this bail amount, you can go home now and you don't need to have a trial. And so you won't get, quote unquote, stuck in the system simply because we don't have court very often. But that's not how it works in practice. And to give you an example of that, I want to talk about Randolph County, Alabama. Now, in Randolph County, they have one of these bail schedules. And earlier this year, working with the Southern Poverty Law Center, the ACLU of Alabama, and Civil Rights Corps, we investigated Randolph County, which is a very rural county, not that far from Birmingham, but far from most other things in the world. And it operates as you might expect, right? So you have a judge who has set forth a bail schedule. You have a sheriff who enforces the bail schedule, and for every arrest, simply attaches a monetary amount to each offense. And then, rather than afford a speedy hearing to those who can't afford to buy their way out, you don't get a hearing on the amount set by the bail schedule for up to a month. Let's think about that. Now, you're sitting in jail before you even have a hearing for 4 weeks, simply because you can't afford amounts that may be as low as $500. So our plaintiff in that case is a woman named Candace Edwards. And I think her story really typifies what happens when these jurisdictions unthinkingly apply these bail schedules under the veneer of justice. So Candace, when we found her, was 7 months pregnant. She'd been arrested for writing a bad check worth $75. Her bail was $7,500. Now, that was set by the schedule. There's a certain parallel to there, but it was just an unthinking application of the bail schedule. And so this woman who was 7 months pregnant was forced into a jail cell with 3 other inmates, meaning she had to sleep on the floor, all because of this monetary amount that had been attached to her case. Happy to report that we filed the next day after she was placed in jail, and she was quickly released. Now, I say quickly released, I leave it a little bit general, because she was released in part because of the lawsuit. The judge, in our case, issued a temporary restraining order requiring her release within 2 hours of filing. But we found out that she had actually been released even before that. She was released by the judges. So we were curious about that, and we talked to Candace, and she said, well, so I was in jail, I knew you guys were going to file, and then this bail bond agent came to the jail, and he said, the judge, Judge Tenney, asked me to come by and bail you out. So I posted your bail, so don't worry about it. Gives her a ride home, and as he drops her off, he said, and actually this is, I think, a fairly frequent service by the bond. They're very accommodating. So as he drops her off, he says, for now, don't worry about the money. We'll work it out. And Candace says, well, I don't have any money to pay you. He said, we'll work out a payment plan. So then, not only finding this bail schedule, we had to call our defendant counsel and say, this is actually not cool. Because at some point, she's going to be brought back in jail because she can't afford this bail bond agent's price tag, and we're going to be in the same situation. So they exonerated that bond, and she's now out on her own recognizance. She's had the baby, she's doing well, her case is still moving forward, but that's just an everyday story that we see in these contexts. And I'll just add, we're at a very interesting place in Alabama now because the state sees the writing on the wall. We've been very active in Alabama on other cases, so is SPLC, so is Civil Rights Corps. So now Alabama wants to try and implement a quote-unquote global settlement to resolve this lawsuit and the others that it sees coming down the pike. So far what they've offered is to keep bail schedules in place, but have a hearing within 72 hours to determine conditions of release for those who can't afford the bail schedule, right? So this is why I say we have to end unnecessary detention, not just wealth-based detention, because now we're in a situation where somebody can still be held for 3 days, which I think is still far too long, on the bail schedule, right? It's better than 4 weeks. I'll give you that, but it's still devastating because we know that in 2 days, everything can change. How am I doing on time? Okay. So the second area that I'll call more broadly than just bail schedules is indefinite detention without counsel. And for this we'll go to usual suspect number 2, Mississippi. Before I go into this, the right to counsel at bail is a thing that is still not established, and one that we at the ACLU are trying to get implemented across the country. And that's the basic failing, or one of the basic failings in this case. All right, so in Mississippi, you had this confluence of issues that really result in people being held in jail for up to a year without counsel and without formal indictment. One is the fact that there's no public defender system, right? The state does not provide any money to local public defense. I think it's one of 6 or 7 states that doesn't give any money to the trial function. Bob can correct me if I'm wrong about that. But there's also, as I mentioned before, there is no limit on how long you can be held in jail without an indictment. And lastly, you have jurisdictions like Scott County where we sued, where the going policy is not to appoint counsel until you've been indicted. So in Scott County, which is, again, if you know Mississippi at all, it's about an hour east of Jackson, the capital, we identified 2 plaintiffs who had been held 8 and 10 months on money bail. Now, the problem here wasn't a bail schedule. The problem here was that both of these men had been arrested by the sheriff and then taken to the judge's chambers, and then the sheriff essentially requested the bond amount. The sheriff. So you also have to understand that in Mississippi, these proceedings are conducted by justice court judges, right? And when I used to just talk about this, I would say, there are many judges who don't have law degrees, and it's actually worse than that, right? Because in Mississippi, all is required is a GED to be a justice court judge in charge of the life or death of pretrial detainees. And so this judge, based on the recommendation of a sheriff, imposes tens of thousands of dollars of bond on Josh Bassett, one of our main clients, for a property theft. Now again, as in Randolph County, as soon as we brought suit, both of our clients were released from jail, which then led us to say, okay, well, if you're going to let them out of jail, that's sort of an admission that they shouldn't have been there in the first place. So we then added damages claims, seeking compensation for the months they had spent in jail. And that ends up becoming very important in the life of this case. Before I talk about that, I want to just give just a quick encapsulation of these, I think, the attitude that results in indefinite detention, and that's from the chief judge of this district talking to the New York Times after we sued and explaining, I assume he thought very reasonably, why he didn't appoint counsel until indictment. This is what he said. The reason is that the public defender would go out and spend his time and cost the county money investigating the matter, and then sometimes the defendant is not even indicted by the grand jury. So I wait until he's indicted. Efficiency. And again, when we talk about how to bring down costs, we have to think about this is how people in these jurisdictions think about bringing down costs. And that has to be a reality in our mind. Then he goes on, and he says, and the reporter asks, well, what if you want to challenge your arrest? What if you want to get your bond reduced? What if you want a preliminary hearing? And the judge, Judge Gordon, Marcus Gordon, said, well, that person can either represent himself or he can employ an attorney. Right, that's the mindset, all right? So the problem with respect to the right to counsel, as I mentioned before, is that this is clearly unjust, but it is not clearly unconstitutional. And so we brought suit, we brought a number of injunctive claims, which were all dismissed, but what survived was our damages claim against the county. And that became the mechanism that we used to settle the lawsuit with all 4 counties in the district and the judges. And so what we wound up with was a public defender system in this district, I think only the 5th in the state of Mississippi. I'll tell you why I shrugged in a second, but I'll just go through this. And also a mechanism to provide counsel at the first appearance. Now I shrugged because the public defender that they appointed while we were settling this case calls me up and he says, I'd met him before the lawsuit, and he says, we've got it all figured out. What we're going to do here is I'm going to get somebody appointed to the case. They're going to have a lawyer, but a lot of times people bond out prior to trial. And you don't want to have to go and see somebody, and then I'm traveling across counties, I have a private practice, I'm a part-time public defender, and so I really don't want to get into the case unless I know the person can't bond out. So we're going to wait 5 weeks, and if the person hasn't bonded out by 5 weeks, then we will file a motion to get the bond reduced and ask for a preliminary hearing. So baby steps. This guy's still running the system. But the good news about the settlement is that we also have a 2-year period of monitoring where we hope to be a thorn in their you-know-what about the general practice prior to trial. My time is running short, and I want to leave at least some time for a question or two. So lastly, I'll mention this idea of ending the profit motive. And for that, I will turn to usual suspect number 3, Louisiana. This case comes out of East Baton Rouge, Louisiana. It involves an amazing setup where a local judge, Trudy White, if you want to look her up, has arranged for a private pretrial company called Rehabilitation Home Incarceration to provide all of her pretrial supervision. So here's how it works. Judge White has a proceeding. It's not a hearing, it's a proceeding where she gets your file and then through some alchemy in her own head decides that certain individuals should go into the custody of RHI, and she writes that in as a condition of your pretrial release. RHI then imposes a rule that in order to get out of jail, even if you've already posted bond, you have to pay them an additional $525 as a processing fee. If you can't pay it, you stay in jail, despite the bond. If you can pay it and you get out, they then have sole discretion to determine your conditions of release, including drug testing, GPS monitoring. They've made up their own self-improvement courses. It's really comprehensive. But for that pleasure, you have to pay $225 per month. So we brought a lawsuit to challenge this. And the idea was, one, very similar to the bail schedule cases, that somebody should not be in jail, especially on a debt to a private company, simply because they can't afford that debt. But we also, and this is, I think, what's more exciting for me as we think about how to go after the private industry, we brought a civil RICO case, as a racketeering case, and said that, holding somebody in jail as a private company simply because they can't afford money, and actually threatening to keep them in jail if they can't afford that money, is extortion, right? It is the... And the law says that there's a concept in the RICO law that says there's something called the illegal use of fear, which I think really encapsulates what's going on in our pretrial justice system. And when I describe this case, it's interesting. People often react and they say, oh, this is terrible. It's so shady. It's so, ugh. But it's almost exactly what happens with the bail bond industry every day. Right? And so our hope is that we can use cases like this to begin to build an arsenal against the bail bond industry itself and take down this notion of profit motive in our pretrial justice system.